SJC-10292, Commonwealth v. Beneche.
Good morning, Mr. Schubert.
Good morning, Chief Justice. If Your Honors, please. On behalf of Mr. Beneche, I think it's important to understand from the very beginning that the government's theory in this case was joint venture. And it cannot be ignored that the 900-pound gorilla in the room, which is like a room of China, is that we not only have the death of the actual mother in this particular case, which is found in a plastic bag floating in the reservoir. We have the difficult situation where a child is killed and that is placed in a plastic bag and thrown out of a third-floor window and misses a police officer by about 18 inches down below. Those are the actual meat facts that involve this particular case. And the difficulty in this case, we would argue, arises from the fact that by some incredible circumstance, maybe it was judicial economy, that the girlfriend of Mr. Beneche was being tried at the same time that Mr. Beneche was being tried. And the answer is that a verdict was reached in that trial prior to the verdict being reached in Mr. Beneche's trial. And I would suggest to you that as a trial lawyer, the three people here, the judge, the district attorney, and primarily the defense counsel, were then faced with an incredible situation, which is the theory of the government's case is joint venture. What are we going to tell the jurors about what just happened?
But didn't your client want that? Yes. Or wasn't that your defense, that you wanted to pin the blame on her, so that you wanted the jury to know she'd been convicted, so then maybe they would let your person off?
I don't believe
She's been found guilty. Justice has been done. She was the guilty one.
I don't believe that that's the key issue here, Judge.
No, but wasn't it the strategy?
The strategy was that he did nothing, and the government really had no proof that he actually did anything.
No.
But the question is,
Didn't your client ask for an instruction to be given about the conviction of Ms. Dean?
Well, and referring, Your Honor, it becomes so difficult because it's on transcript 4, page 88, where the judge brings to the attention of the attorneys. He says, I wonder if the attorneys have given any thought to any special manner in which they wish me to handle the verdict in the Dean case. It's possible that the attorneys might want to stipulate as to something that I should tell the jury or take the position. And I go on just a few more pages where...
Wait, why did the jury have to know about the conviction?
Because they were afraid that they'd hear it on the news.
Everybody's afraid of the media.
And I believe that the court is grappling with this in the trial court on a constant basis. That's why we need help from the SJC. I mean, we have Justice Mulligan issuing an order, as I understand it, on March 25th, 2010, saying that we can now take cell phones and smartphones away from jurors so that they can't be Googling information while they're in the deliberation room or while they're listening to the trial. And they were faced with this situation. And
so what does that have to do with this case?
It has a lot to do with this case.
They can still Google after trial.
But then they will reach their decision if they're Googling while the trial.
What? They can Google when they go home that night before they come back to deliberate.
Well, I'm just telling you what I understand to be the new...
Well, let's go back to this case.
But this case is that the judge then says, I do share the concern that it's very difficult. Obviously, the defense counsel, at the very beginning, he says, no, I don't think I want that set. For obvious reasons. The only evidence is joint venture. If you say to people...
Oh, okay. He says that, and then what does he say?
Well, that's what's interesting. There is no stipulation that I can find that actually makes it into the record. But if I can, directing your attention to, which is transcript 4, page 293, this is what the judge says to the jury. And it's what I think absolutely sinks any ability of the defendant to get a fair trial. He says, first, you've heard information. The trial that Jessica Dean, the alleged girlfriend of the defendant, I want to tell you that she was tried and she was convicted by a jury. Now, I tell you this because it's conceivable you'll find out, even though you strictly adhere to all my instructions about picking up extraneous information, etc. Sometimes it's almost impossible. So I just tell you flat out that she was convicted of both counts of the murder of Kayla and of Xavier. But I want to stress with you that it is of no evidentiary significance in this trial, that it is a different trial, the evidence was different, that it's a different jury, and it would be wrong for you to somehow to take that into account when you eventually, the case is presented to you for deliberation and decision. As I've said repeatedly, and I'm sure you know, you're expected to judge this case not on any other case, only on the evidence introduced at the trial. So it is of no significance to you whatever that Jessica Dean was convicted by another jury of murder with respect to these two victims. Again, the reason that I share this with you is that it's conceivable that you'd find out anyway, and I don't want you speculating about the consequences of it. The court is giving this, and there's nothing clear in the record as to whether or not defense counsel asked for this.
I can't conceive of an instruction like that being given without the agreement of defense counsel. Can you imagine that?
I can't imagine that defense counsel went along with it, but defense counsel in this case obviously has other problems, and the answer is...
But isn't it consistent with the defense? Dean did it. And wasn't that used by the defendant? Isn't that the point? Justice has been done.
My point is that my second argument in this brief, which I don't see addressed at all in the government's brief, is that this is an ineffective assistance of counsel claim because no one in their right mind on a case that the only thing is joint venture would allow the jury to know that the other person has been convicted, especially with the fact that we're still dealing with the fact of a 3-year-old child being tossed out the window with a plastic bag.
But his statement was that she did it.
Yes.
So
and there isn't a whole
he
lot
says his defense is not that it didn't happen or we had no connection to it. He says she did it, and after the fact, I helped get rid of the bodies. And then so he says, I want the jury to know that she was found to have done it. And then he can say, a jury, and he argues, I guess, in closing, a jury's already found that she did it, and my guy didn't. And I ask you to find that my guy did not. He simply helped after the fact. He was the fool who helped get rid of the bodies. Why is that not a, at least arguably, reasonable defense strategy?
It is not a reasonable defense strategy because now you have to also look at the argument that I make relative to the fact that this is a joint venture case and the instructions that were given in the joint venture case. We know that joint venture is somewhat of a difficult theory for jurors to understand when they're presented with the facts in this particular.
You say there's not sufficient evidence, right?
I'm saying that, number one, the government did not have a whole lot of evidence, not DNA or anything else that actually proved that Mr. Beneche did anything, and that it was pretty clear that most of the evidence obviously went against Ms. Dean.
Well, they did have, they had DNA or blood from inside a glove and...
Of which they couldn't actually really do definitive testimony relative to what the real significance of that was, Your Honor. But the problem becomes is that when we give the final instructions, and this becomes an issue in this particular case. Obviously, I got the brief, I believe, on like April the 23rd from the government, and they had filed extensions. But before that, I received a letter from the government that says that, Mr. Schubert, the third argument of your brief, that the instructions are wrong, is incorrect because I've gone to the stenographer, and the stenographer has changed what is the official transcript in this record. Now, as I understand it, there are certain rules that apply to changing a record, and I suggest to you that they weren't done in this case. I suggest that you shouldn't even involve any theory or give any credence to that part of the Commonwealth's brief that suggests that I'm wrong in my argument. And it relies on the fact that we argue in our brief, and prior to me receiving a letter saying that the word if was added, if you find it is proved that he was a joint venturer. And we say that the official transcript says it has been proven he is. And that key issue in the instructions is whether the word if was actually there or not. Now, the government has not filed the appropriate motions or anything to get that before the court, in my humble opinion, and I ask you to take credence of that particular point. And when I received the letter from the government, I sent a letter saying, can I have the tape of what the judge really said? And to the best of my understanding from the responses that I've received, there is no tape of what the judge allegedly said. And when you dovetail these mistakes together, what I claim to be a horrifying ineffective assistance of counsel claim in a case where the government's theory isn't supported by a whole lot of material forensic evidence to prove that Mr. Beneche did anything, and it's only joint venture. And joint venture is a difficult situation in a case where you're trying to apply it where a baby gets thrown out of a third-floor window. I would suggest to you that the cards were stacked against Mr. Beneche such that he could not possibly get a fair trial and that he was not afforded procedural due process. I don't suggest that it wasn't a difficult situation for both the judge, the district attorney, and also for the defense lawyer, because the defense lawyer starts out...
If you'd slow down, I mean, I'm trying to figure out how these arguments piece together. What do you say is with regard to this purported error in the transcript, what do you say is the appropriate procedure when one party says that the transcript is an error, that's not what was said?
I believe that they should file a motion to correct the record, have it actually heard, sending me a letter just telling me that I've gone to the transcriber, the person that took the transcription, and that person has now said that, oh, the word if really does belong there. It's not an appropriate way to bring this before the court, nor to correct the record. To the best of my knowledge, that's all that's been done in this particular case, and I don't believe that that's correct, and the court shouldn't consider that argument. It's only like a half paragraph in the government's...
Wouldn't you agree with me that we should try to clarify what, in fact, the record is, not discard the argument? I mean, perhaps we need to take more steps. Maybe there is stenographer's notes that would suggest that she made a typographical error. I mean, should we just disregard? That's a very important if.
Well, it would be really critical, and to the best of my knowledge, I have requested a tape, and it's to the best of my knowledge that no tape allegedly exists. If that's the case, I find that to be unusual as a trial attorney.
When you talk about a tape, are you talking about an audio tape or the...
An audio tape that would be either in a transcription machine, or if the stenographer was using a voice thing, you would think that there would be a tape of what was actually said.
Mr. Schubert, I'm sorry that I don't know this because I did read the letter, but was the correction made before or after your brief was filed?
Oh, it was made way after my brief was filed. I received the letter on...
No, I know. I remember the letter. I just can't remember what the letter says.
The court reporter mailed a certified version of the amended transcript to the Superior Court on April 7th, 2010. So it's after.
And I received a letter on April the 9th informing me...
No, I know that, but I couldn't... I just don't know when the request was made.
And to the
unfortunately, we have had some problems with transcripts, and I don't know when the request was made. If the request was made after your brief, and I don't think the letter makes that clear. Maybe it does.
I don't believe so either. So, if in fact we have the difficulty with the joint venture, coupled with
the difficulty about joint venture, what do you mean by that? Are you claiming the instruction was an error?
I am still going back to the fact that it is our position that telling the jury about the Dean verdicts was wrong. And to say that the defendant is saying the Dean did it all does not take away the taint and the problem with procedural due process, because you're trying to say to a juror who is concentrating and doesn't spend his life listening to murder cases that a baby got tossed out of a third-floor window in a plastic bag, we don't want you to think at all over the fact that the other person was convicted by another jury of killing these two people by extreme atrocity and cruelty and premeditation, malice, and forethought. Don't think about that. I say to you, judges, that that is totally impossible with any lay juror that we would have.
So what would we do? You have to have a trial of this man. What do you do? And the verdict came back, as it happens, the verdict of the woman came back during the trial. So what do you do?
I would suggest that we don't have the problem of trying the cases at the same time.
Well, if you try them sequentially and the woman's tried first, then the jury will probably, because they wouldn't have been picked yet, will have read about it in the newspaper. So that's going to happen.
But then they could have been dealt with in the voir dire relative to whether or not we were going to seat them and whether or not they had in any way been influenced by anything that they knew. In this particular case, that was not available to the defense in this particular case. So it made a big difference, and I'm not absolutely certain why we had to try these two cases at the same time.
Did the defendant ever move not to do so?
Not that I'm aware of. I see nothing in the record that would substantiate that, Your Honor.
Could I change subjects?
Certainly.
With respect to the arguments that you make about post-arrest, pre-Miranda, post-Miranda statements, or what I'm trying to figure out is this. There was a statement, or there was a silence, pre-arrest, pre-Miranda, in the bedroom. But you haven't argued that. Is that right?
Well, if you look at my Doyle argument, which I have to apologize to the court because I must be getting old, I argued Doyle but didn't include it as a case cited in my brief. But I made a Doyle argument. And what I suggest in my argument, I believe, Your Honor, is that the way they got this in is like a backdoor thing. They say, well, he gave a statement later.
No, I understand that. But your challenge seems to be to, it appears to be to silence as they're going down the stairs and Miranda rights are being given, outside as they're walking by the garbage bag, and in the car.
And what I'm suggesting...
In the police car. There's another statement before, and I'm just wondering if you are challenging that or you're not.
I'm challenging anything that when the baby was thrown out the window in the trash bag, and they come up and there's conversations like,
yes, I
you
know,
incredibly
right.
horrible human being,
Right.
You did this, and Mr. Beneche doesn't respond to that.
Right.
And I'm saying that that's Doyle error because they backdoored it in through when he gave the actual statement, but they took advantage of his silence in that situation and got it before the jury because then they argued that any normal human being would be a little bit repulsed by the fact that somebody threw a 3-year-old baby in a plastic bag out of a window. And they got it in, and I suggest to you that that's Doyle error, even though I was clearly negligent in actually citing Doyle in my brief. So I will make the appropriate letter to add that. But it was a Doyle argument, and my sister at least understood that and put...
No, it was really a question of
but
what you were
I believe that they took
including in that.
advantage of that, and it's further evidence of the fact that they had to take advantage of that because they didn't have a strong forensic case or anything that really linked Mr. Beneche to the actual killings.
You say that, but all right, to the killing, but you've got not only the blood in the glove, there's blood, his blood on a rock in the kitchen, there's
That's
on
correct.
the dryer, there's her blood. I mean, you know.
I would suggest to you that if you closely read the
You also
transcript...
certainly have a lot of motive evidence.
Well, in talking about motive, it is interesting that the government puts in their brief the argument that there was certain emails sent and certain responses, but I do point out that the last conversations that Mr. Beneche had was, he had said first, I hope that you live in hell or something like that, and then later he says, I'm moving on, I hope that you have a good life. If you look at the two things, it's in the government's brief as to what was actually said. If you look at the absolute last thing that Mr. Beneche allegedly said to the deceased wife was, I'm moving on and I hope that you move on and have a good life too. It's in their brief. They cited both of the articles. Obviously, at some point in time, there was a tumultuous breakup here, and there was little love lost at certain times. That's true. There's no doubt about it. But if that was true, that everybody that entered into a relationship that had those type of situations was charged with murder in the first degree, and that's what basically happened here. They used his silence against him. They didn't have a strong forensic case. And when they didn't have a strong forensic case...
Well, they had him carrying the body out of the apartment. And where is the child's body kept? In his bedroom, in a closet? I mean...
not say that there is any direct evidence that they had evidence that they saw the body being carried out.
The two people were taking
a
big trash bag, struggling with it to get down the stairs.
Absolutely.
You don't think that's a
A
reasonable
heavy bag.
that they're struggling to carry? You don't think there's a reasonable inference? And the body is found wrapped in dark trash bags in the
The only
reservoir?
reasonable inference that I would argue to you is that there was a government case for being an accessory after the fact to murder, but there was nothing more in the government's case than accessory after the fact to murder. That's our position, and our position remains changed on the fact that there was no competent defense lawyer that would have allowed for what the judge told the jury about what happened in the Dean case, because there was no juror that sits in the Commonwealth of Massachusetts that could separate themselves from the horrible facts in the case and joining Dean with the joint venture theory that was being given to them by the court. And that's taking out of the consideration entirely whether or not the word if was there or not there. It's just a fact that this could not have been correct. Whether or not, as trial attorneys, we believe that the jurors are actually following their oath is a different thing, but the fact is telling them at this point in time was horrible.
There was no, there's no motion for new trial on that issue, ineffective assistance. Has there been?
No, I've raised it, I believe, as an ineffective assistance of counsel in my brief.
Thank you, Mr. Schubert.
Thank you.
Good morning, Ms. Kaluli.
Good morning.
Can we just deal with the transcript proper? What is the status of the stenographer's law material from which she prepared the transcript?
Just a moment. With me today is the Assistant District Attorney Patrick Hagan, who is the trial prosecutor here. When I received defendant's brief, I read through, and there's obviously a jury instruction issue, so I went and I tracked down the Judge Brady actually records his jury instructions to the jury, and it's actually marked as Exhibit M, and I know it has been transmitted up to this court. So I listened to that and then contacted the court reporter. She indicated...
And I take it when you listened to it, you heard an if. Is
yes,
that what you're saying?
I heard an if there, and I wanted to verify that before I got the court reporter and various other people involved. I contacted the court reporter. It took, she lives out on Martha's Vineyard, it took an extensive period of time for her to send in the letter. From what I understand, the Superior Court received it Wednesday or Thursday of last week, and from what I understand, it's also been transmitted up to this court.
What's the it in that? The letter?
I'm sorry. There's she amended the transcript. She included.
No, I understand that. Do you not think it would have been more appropriate if you thought there was a transcription error, and especially in a murder one case, to, file a motion and ask for a correction of the record?
Yes, and I think that is the next step that needs to be taken. However, given the time constraints and the lack of information that I received from the court reporter, I tried to get the information to defense counsel. There was a letter from defense counsel to me requesting the tape, and I replied back, I don't have it. However, the court reporter can access those tapes for you.
Do we have the tape? Have the exhibits been transferred up to this court?
From what I understand, there are two tapes. There's the actual tape recording of the entire trial, which is in the Superior Court that the court reporters have access to. In addition, there's an Exhibit M for ID, which this court does have. It was transmitted up with all of the exhibits.
Which is Judge Brady's voice.
Exactly.
Okay.
You can listen to it and you can
I think in the future what would be appropriate, you could have done one of two things, to say, listen to Exhibit M and you'll see that there's a problem, or move to correct the record so that everybody has notice. I think what we can't be doing is having stenographers being contacted ex parte and asked to correct the record. I think that creates a problem. If you'd simply asked us to listen to it, and if it's so clear on the tape, it would have become obvious.
Let me just ask you this. On that same subject, I thought, but I could very well be wrong, that in your motions to continue the date to file your brief, this was referenced. Is that
yes.
correct?
Yes.
This issue was referenced?
Yes, it was. And I didn't want to, as I did in my brief, which I subsequently filed, not address an issue if
No, that's fine. That's what I'm saying. You could,
yes.
a relatively simple way so as not to prejudice the Commonwealth's rights would have been to say, listen, if in this case we happen to have it because he sent the tape into the jury room, which is what you listened to, and that would have been fine, and then you can file a motion to correct, and that would have been fine.
Okay.
But, nothing's missing, in other words. We've got the law. Okay.
No. Yes, and it's equally accessible to the Commonwealth and Defense Counsel, as I made him aware. Moving briefly to the stipulation, this is an odd circumstances, and I think a little bit of context is necessary here. Dean's trial was presided by Judge Brady as well, in the same courtroom as Beneche's trial.
So it was morning and afternoon?
No, actually, the jury was given the case, and they were deliberating in Dean's trial when the Beneche case started, when they began impaneling. On day 4 of the Beneche trial, which was the second day of testimony, That's when the verdict came back in the Dean case. Same judge, same courtroom, lots of media. The judge rightfully thought that the jury in Beneche's case would likely hear of the verdicts. So he brought the question after the verdicts were returned to both counsel and said, how do you want me to deal with this? Do you want me to say anything? Do you not want me to say anything? What would be the best course of practice? I'm worried about media. In addition, obviously, the Beneche jury was sent out while the verdict was returned, and the sentencing occurred. At that point, defense counsel did say, I'm not sure, let me think about it. And Judge Brady said, okay, Commonwealth defense counsel, talk about it, let me know. We can even say something tomorrow morning if you want to take the rest of the day. By the end of that afternoon, they came back and they said, we've talked. Defense counsel very clearly said, we agree, this is a stipulation, we want you to read to the jury. The judge then reviewed the stipulation with both defense counsel and the prosecutor prior to informing the jury of the stipulation. Stipulation actually was very interesting, and it says, yes, she was convicted of murder, but don't pay attention to that. There's different evidence here, different facts, different person. It's similar, I would suggest, to a witness who inadvertently says something, there's a motion to strike, and the judge then instructs them, you're not allowed to consider that. The jury was informed, and that was the end of it.
And I take it was not used in the closing argument?
Yes, it was.
Actually, it was used in the closing argument.
By the defense?
It was, yes, it was.
I mean by the Commonwealth, I'm sorry.
Well, it was used by defense counsel. Defense counsel pointed at, he said, let me get the exact language here. He said, we know Dean is involved in this. She's been convicted, so the overwhelming evidence is that she killed the baby. So defense counsel, despite the judge's instructions, actually does reference it in closing argument.
Which is improper.
Yes.
It wasn't supposed to be considered.
No, it wasn't supposed to be considered.
But it is consistent with the defense's strategy that Dean's the bad guy here. And
Well, not in a joint venture trial. Because if you're saying two people are responsible, they're involved in this, and the jury comes back and says, one jury comes back and says, she's guilty. I mean, if it's a joint defense trial, that's pretty much, well.
But the defense
But
was
the
it
defense
wasn't a joint venture.
The defense was that it was only her.
No, I understand that, but the Commonwealth is saying they acted jointly.
Well, the Commonwealth, yes, that was our theory of the case, that they acted jointly. And so in closing, there is a brief reference to the convictions. However, the prosecutor
By the Commonwealth as well?
I'm sorry?
By the Commonwealth as well?
Yes, but it's specifically in response to defense counsel's reference to the convictions. And the prosecutor said, like defense counsel said, she's been convicted, but she was a joint venture. The decision for all of you to focus on, the facts for all of you to focus on, is what the defendant, James Beneche, did. So even though he acknowledges that she's been convicted, he properly focuses the jury on, we're here to discuss the actions of the defendant.
No, I understand that. I mean, the judge clearly had a problem, because think about the alternative. The alternative is you essentially have, not a voir dire, but he is sufficiently worldly to know that they may run into, something or learn about it, and he can either say, now something has happened in that other trial, and I want you to keep it out of your mind, or he can deal with it in a pretty straightforward way. I think that the problem then is when you have counsel not obeying his order.
Yes, but I think I think also, as this panel has raised numerous times, this does go in line with the defense. The defense was, Dean did it all. My client, the defendant, came in afterwards. He saw this in his home, and he cleaned up because he thought he would be accused. He was only an accessory after the fact. So
there was an accessory after the fact instruction given. Is that?
No, because you can't be an accessory after the fact to the crime that you commit. So he was charged with 2 counts of first-degree murder, so there was no accessory after the fact.
Okay.
Instruction given. Unless there are any more questions about the stipulation. Moving to the evidence of joint venture, there was ample evidence here that the defendant was present in the apartment and, in fact, participated in the murders. First, it had to have been the defendant that was able to procure Kayla and Xavier's presence over at the apartment. There's ample evidence that Dean and Kayla did not get along. Kayla feared Dean.
So how was the presence procured?
We're not sure. We do know
Couldn't
that
somebody email on somebody else's computer? I mean, it happens all the time.
it could have been email, it could have been phone. We're not too sure. However, even allowing for the possibility that, for example, Dean used the defendant's email address, once Kayla and Xavier got there, they still had to get her into the apartment. And if the defendant was not there, I would suggest that Kayla and Xavier would not have got up. They went to bed that night from the testimony of the mother. They woke up at 11:07, still in their pajamas, went over to the house. We don't know how or why they went there, but presumably when confronted, if it was Dean who was the only one there, as the defendant submits, they would have turned around and went away. Dean had made numerous threatening phone calls to Kayla. She threatened to kill her, to shoot her. She made statements to everyone else, and Kayla was aware of this. So the idea that Kayla with her 2-year-old son would have gone into this apartment when it was only Dean is rather implausible.
What do you say about the statement that that was admitted when the police officer said, you know, you horrible person, you've thrown your baby out the window, and the defendant didn't answer anything?
Could you go through each of those statements one by one?
Sure. There
That'd be
are
great.
a number of... so we have when Trooper Tobin is up there with the defendant, they've pulled him out of the bedroom, and he's standing at the top of the stairs. Trooper Tobin, they're having a conversation. Tobin asks him, have you seen Kayla? Have you seen Xavier? He says, no, I haven't seen him for a week. He starts to ask him this in various forms. Sometimes the defendant answers, sometimes he doesn't. But essentially he says, no, I haven't seen him for a week.
No Miranda, no arrest, not custodial, just what do you know?
Exactly.
And he's answering. Right. He's answering at least some.
He's answering, and he's standing there, and his demeanor is normal. He's saying, nope, haven't seen him for a week. He stands there. They're having this conversation. The other officer, Sergeant Detective Goslin, he comes up the stairs, and admittedly, in language that he is not proud of.
Very shocking incident in any event. Baby is dropped right next to him.
Exactly, and he's very apologetic, but he says, you know...
he says what he says.
He says what he says. And the defendant looks at him and doesn't say anything. They arrest him, they Mirandize him, take him down the stairs to get him out of the apartment.
So the defendant's silence in response to that provocative statement is used?
Yes, he testifies to it. And I think it's interesting to note that the defense counsel does actually request a sidebar prior to this testimony coming in. And his issue with this testimony is not the defendant's demeanor or the silence, if you will, or response to the statement. His issue actually is Sergeant Detective Goslin's statement, because Sergeant Detective Goslin says he threw the baby out the window.
Okay, but whether he objected or not, do you think that was appropriate to come in?
I think it was, because it's part of a conversation. I mean, the other thing to look at here is from the time that the officers arrived at the apartment, it was 2:15 in the morning, to the time he signs his Miranda waiver at the police station, it's 3 a.m. So we're talking the difference of 45 minutes here, over which time the defendant actively interacts with the police, he talks, he makes statements.
But after the conversation, have you seen them? No, I haven't seen them for a week. And then the baby, they discover that. Did the defendant say anything from then to when he gives his statement at the police?
Yes, he does. When they pass Xavier's body, there's a question of how could
he says, I don't want to talk about that.
He says, I don't want to talk about that. When he gets to the transport, there's 2 officers who are going to transport him to the station. He has an interaction with them when they pat frisk him. This isn't a person who...
But that's the one about, all I have on is boxers. Of course I don't have any, I don't, right? I mean, it just seems to me that there's a lot of, well, there are a number of times where he doesn't react, and that is used at trial. And it would seem to me that you've got, after the first one, post-Miranda, post-arrest silence being used substantively against him.
It is used by both parties at trial, because before this you have an extensive amount of evidence about the defendant's demeanor from the time the murders happened to the time that the police show up at his apartment. Various witnesses describe him as normal. He's holding hands. There's photographs of him at the hospital. He's holding hands with with Dean. There's some neighbors see him, say, he seems normal. He waved at me. The coffee shop owner says, And it goes to the defendant's theory that, well, actually it goes to, the defendant's theory was that he showed up, he sees these bodies, he needs to help dispose of them because he doesn't want to be charged, and that he's in shock after this, and that explains his demeanor because, quite frankly, if you're confronted with these two murders, you might have more of a reaction. But he has all of this other evidence that he somehow needs to explain, because after you do this, chances are people aren't going to describe your demeanor as normal.
Okay, but you acknowledge that there's a difference in the question, what was his demeanor when this was said, versus what did he say, if anything, in response?
Yes, there is a little bit of a difference there. And to the extent that this is, in this time frame, that there is some gray in terms of what should properly have been admitted and what wasn't, putting aside the fact that the defendant used this evidence, didn't object to it, and it actually went into his theory of defense, then, as I said before, it was all unobjected to, and we look at substantial likelihood here, and it simply doesn't rise to that level.
Isn't even his demeanor, I'm thinking about Commonwealth versus Thompson, isn't that a demeanor? Isn't that the same thing, looking down at the floor for 30 seconds?
There is, but I think that Thompson, for that, can be distinguished in terms of, in Thompson, the police arrive at the door, the defendant says, yes, I'll speak to him, they inform him, your wife has been killed, and then he looks at the ground for 30 seconds. Here, there's already been interaction with the police. He's already talking, he's already engaging with Trooper Tobin, and that continues through the rest of the 45 minutes there, and when he gets to the police station. I would suggest it's actually more akin to the part in Thompson where, when he does actually give a statement, and he doesn't make inquiries about the welfare of his child, that was probably admitted.
I know you argued that. I'm not sure I agree with it. Could I, unless, you go ahead. Did you have a question?
Oh, yeah, well, I was just going to ask you, I don't think this is argued by the defendant, but of course we conduct a Section 33E review here. And I'm wondering about the evidence that Kayla could not be included or excluded as, am I in the right page?
Yes.
Yeah, as a possible contributor of the DNA and the blood found in the latex glove in the Chevy. Was adequate statistical evidence provided to the jury in accord with our decision in Matte, 455 Mass 840?
Yes, I believe so.
The statistics went in, explaining that the likelihood that the test, what was the likelihood that a test couldn't exclude other individuals in a given population?
You mean the actual numbers?
Yes.
Yes, it did.
Okay, good.
I wanted to ask you about the evidence of Kayla, the victims, going to the police before and
Yes.
reporting domestic violence, an incident. And do you disagree that those statements made to the police, when was that in relation to this murder?
They were, all of the incidences were within a year prior to this. I think that was maybe 9 months prior to the murders.
And when she went to the police, right after it happened, is that?
Yes. The testimony that we have regarding that incident came in through the officer who was at the police station. She showed up. She was crying. She had red on her face. It was swollen. And she said, he hit me.
Okay. So that may get you past the hearsay problem.
Yes.
But what do you say about the confrontation problem? I mean, because it seems to me it is testimonial in fact.
That's, the record isn't developed enough, I think, to make that determination. And I think to the extent that it is testimonial in fact, there's no substantial likelihood here.
What was it being admitted for? What was the purpose, state of mind?
Hostile relationship.
Motive, intent, hostile relationship.
So it's not being offered for the truth.
It's, no, not necessarily being offered for the truth. However, I can see the argument that it is. Okay. Aside from all that, really it was cumulative of all the other evidence. I mean, there was extensive evidence of a hostile relationship between them. The complaint of this issue was coming in, and in that it was defendant assault and battered this victim. So the fact that she said, he hit me, is really rather cumulative of the complaint. In addition, there were other incidents of mutual combat between the two that actually came in. So even if this court were to find that those statements were testimonial and improperly admitted, it really doesn't affect the outcome.
Well, why
here.
were the complaints coming in?
To show the hostile relationship. The Judge Brady specifically made a finding that the fact that she filed a complaint, regardless of the truth of what the facts were, the fact that she had taken it a step further, the actual filing of the complaint was relative to the hostile nature between the two.
Near the beginning of your argument, you started to kind of list what you thought were the significant points that show the sufficiency of the evidence of joint venture, and I think we interrupted you. So, and you talked about he had to have gotten them there. That was one, and
Yes.
then I don't know what else you were going to say.
So we have that, and then there's also the fact that there were two victims, and the nature of the injuries show that the manner in which they were killed would have required a long period of time. This wasn't a shooting where death could have occurred instantaneously.
I understand that the killing of the mother might have taken a long period of time, but this was a child.
Even the child, the testimony was that it could have taken up to 2 minutes to asphyxiate him.
I know, but that doesn't suggest to me that you need two people to do that.
Perhaps not, but here we're at a required finding, and all inferences are drawn in favor of the Commonwealth, and this is one step in the chain. In addition, the nature of the injuries, there were diverse injuries to both parties, and under Commonwealth v. Phillips, that could lead the jury to infer that more than one perpetrator was involved. In addition, the defendant had cuts on himself, indicated he was involved in the struggle. The ample motive evidence.
What about the blood evidence at the scene? The stone, was the stone used in the assault? Or?
No, the stone was actually not used in the assault. At least that wasn't the theory of the Commonwealth's case. However, the defendant's blood was found on it, which was on the table, which was nearby the dishwasher where the victim's blood was found. In addition, the defendant's blood was found in the latex glove, which also had Kayla's blood on it. Unless there are any other questions?
Thank you, Ms. Khalil.
Thank you.
SJC-10292.